What's the text like this morning, this matter?
It is your worship. My name is Anis Kalibala. The team that is representing the applicants is led by Black friend Elias Uwabo and Samuel Moizi Mudindwa, Aaron Kizza, Kunihira Boscovia, Kato Tusime, Kakuru Tusime, Simon Owe,
Mawe?
Owe, E-W-O-W-E, Safaruk Kamergea, Satukume Moses, Mr. Silas Okuru,
Cyrus?
Okuru, Mr. Second Jacob Beka, Mr. Chitu Michael, Mr. Bayan Nawe,
application. The applicant brought this application by notice of motion under Article 23, Clause 6 of the Constitution of the Republic of Uganda, 1905, Section 15 and 16 of the Trial on Indictments Act, Cap 25, and Rule 2 of the Judicial Criminal Procedure Applications Rules for orders that A, the applicant can be admitted to bail and released from remand or custody. The grounds of this application are stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that A, on the 21st day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrate Court of Nakawa at Nakawa and remanded in custody. B, the offenses with which the applicants are charged are only bailable by this honorable court. C, the applicants are responsible citizens of Uganda who have permanent places of abode as follows. First, applicant at Buyinja LC1, Wampe Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukonjiri Municipality in Rukonjiri District. Second applicant at Kisigula Village Cell, Mutundwe Ward, Gombolola Sabagabo, Makinde Wakiso District for the second applicant. D, the applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for many submissions. It was submitted for the first and second applicants as follows. Article 23, 6A of the Constitution of the Republic of Uganda as amended spells out the right of an accused person to apply for bail and enables this court to grant bail on such conditions as it considers reasonable. Section 15 of the TIA, Cap 25, provides that this honorable court may at any stage of the proceedings release the accused person on bail. Pursuant to Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Constitutional Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel further cited the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. One of the exceptional circumstances that listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16th November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Tracy J. Charles versus Uganda, criminal application number 8 of 2011, counsel said that the courts have recognized that prison conditions are not favorable to the health of old people, who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides for that other factors that the other factor that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants said that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious, grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. That in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24 of 2024, the International Crimes Division of the High Court, ICD, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application, and held that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provided that doing so does not compromise the interest of justice. It was further submitted for the applicants that the nature of the offenses with which the applicants are charged are political offenses, and that these two are not. And on that account alone, the kind of offenses in respect of which bail cannot be granted for court include antecedents of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panjo versus R 1973 South African Law Reports at page 282, where the court held that allegations of interference with witnesses must be substantiated, and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in applications for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. In reply, counsel for the respondent submitted as follows. Section 15 of the TIA and guideline 3 of the bail provides conditions that court should take into account in considering bail applications, including the substantiality of sureties, nature of the offenses, age of the applicant, possibility of interfering with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Guideline 15 of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties: the age, work, residence of the sureties, character and antecedents of the surety, relationship of the surety to the accused, applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties. To wait, Honorable Semuju Nganda, a close friend, age 52 years. Honorable Francis Mujuche, a close friend, age 41 years. Honorable Mohindo Harold Tony, a close friend, age 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, age 50 years. And that the second applicant, produced by Najita Halima. The second applicant produced Najita Halima Lutale, a wife and aged 58 years. Nafuka Zuhura, a daughter aged 27 years. And Counsel Sewa Kambo Hamza, a friend aged 48 years. Counsel submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And in such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. I also cited the case of Mugera John versus Uganda, criminal administration application number 21 of 2025 at International Crimes Division. Honorable Lady Justice Alice Komuhanji Kawuka held, it is my considered view that a surety should possess a certain amount of authority and or influence over the applicant. The sureties presented by the first applicant have no authority and or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from LC1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, counsel submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. The first applicant produced only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Counsel add that friends do not have the necessary leverage or influence to ensure the first applicant's compliance and are most likely unwilling to take steps to enforce compliance. Counsel cited the case of Tusime David versus Uganda Criminal Administration Section number 29 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Counsel said that if court was uncomfortable with raising the applicant basing on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to release the first applicant with just friends as sureties. In his submissions, counsel submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicants dispense this requirement. Counsel cited the case of Mugera John versus Uganda Business Application number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Alivisa upheld the above view. It was further submitted that none of the sureties provide their work or business identity cards. What was annexed are passports and national IDs, which have no relationship with the business or employment or gainful income and disposable income, which are critical in assessing their substantiality. In Asimu Anna versus Uganda, criminal misdemeanor subject number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability of by the sureties, regardless of their position in society or government, is fatal and goes to the core in the grant of bail applications. Advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved as was held in the case of Tumusime David versus Uganda criminal misdemeanor application number 29 of 2019. The offenses with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Kano retired Dr. Kizza Besigye, Constitutional Reference number 20 of 2005, the Justice of the Constitutional Court held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offenses. The court must weigh the gravity of the offense and all other factors of the case against the likelihood of the applicant absconding. In the case of Foundation for Human Rights Initiative versus Attorney General, Supreme Court Constitutional Appeal number 3 of 2009, the Justice of the Supreme Court held, among other things, that this article imposes on courts the duty to ensure that they do not only consider the rights of the accused person applying for bail, rather, the court should also consider the interests of society at large. The first applicant has another pending charge pending against him at Buganda Road Chief Magistrate Court, which is part hard. Section 15, subsection 4 of the TIA provides other pending charges as a consideration court should take into consideration in deciding whether or not to grant bail in an application of this nature. In the case of Honorable Alan Sewanyana Aloysius and Honorable Segirinya Mohammed versus Uganda, Masaka Criminal Application number 18 of 2021, Justice Lawrence Toyanze, while dismissing the application for bail, held that in an early application granted the applicant's bail, Lady Justice Victoria Nakintu, based on the fact that they had no other charges pending against them, but at the time of determining the present application, they have charges of murder against them, in addition to those they were earlier charged with. It was therefore submitted for the applicants, for the respondent, that the pending charges against the first applicant are a good ground to dismiss his application since he committed the current offenses while on bail via Buganda Road criminal case number 624 of 2023. In a rejoinder, in respect to the fixed place of abode, it was submitted for the first and second applicants that whereas the respondent contends that both applicants do not have fixed places of abode because they did not provide land titles or tenant agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both first and second applicants provided evidence on oath by way of 2 affidavits and attached LC1 letters in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided two locations at Buyenja LC1, Wampeo, Ward Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Kisigula Village, Cell, Mutundwe Ward, Gombolola Sabagabo, Makindi Wakiso District, also within the jurisdiction of this Honorable Court. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Uganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent has not provided any evidence of the stage at which the case at Uganda Road is, or whether in fact the first applicant has been put on his defense or found guilty. That he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Uganda Road case cannot be used against him, as it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail. Regarding the possibility of interfering with witnesses and the investigations, counsel for the applicants submitted that in Panju versus Ara, 1973, Volume 1, East African Road Courts at page 282, it was held that the allegation of interference with witnesses must be substantiated and that such substantiation is not difficult to show. Counsel submitted that there is no evidence that there has been placed before this court by the respondent to show that the alleged strong likelihood of interference with the witnesses or investigations. Counsel prayed that this honorable court finds no likelihood of interference with the unknown witnesses or investigations and dismisses the argument of the respondent on this point. While submitting in respect of applicant's age, counsel submitted that the courts can, and in this case, should take judicial notice that prisons are not holiday destinations. That the fact that there are harsh conditions on remand has been taken as applicant, then the judgment should not prejudice the second applicant, and that the evidence of the first applicant's mastery of the game, presumably referring to fleeing from Uganda, is not supported by any evidence. Counsel further submitted that the first applicant has demonstrated that in the past, when released on bail, and he required to travel outside the jurisdiction, he only undertook it with permission of the court. He would go out of the country and return. Regarding the sureties, it was urged for the applicants that the sureties presented were advised about their role of by the honorable court, and none of them protested or said that they were unable to perform their roles. In Kawanguzi Sereko David versus Uganda, criminal misdemeanor application number 426 of 2023, the court held as follows. It is my considered view that the role of a surety goes beyond the ability to forfeit the bond. Bail is not designed as an income generating avenue for courts to which bail applications are made. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identify themselves properly and have shown and proved their authoritative relationship in respect to which the applicant showing that they are able to exercise their authority and command the appearance of the applicant in court when needed. As for the applicant, informed court that the sureties had been informed of their duties in respect of bail, which duties they understood well and committed to executing. Counsel further submitted that a proposed surety is required to provide a copy of his or her national identity card, and B, an introduction letter from the local council one chairperson of the area where the surety is ordinarily resident, as provided under bail guidelines. Council further submitted that the ages of the sureties, which ranges from 27 to 58, demonstrate adult persons capable of understanding what they are undertaking, and that none is a minor and none is a person of extreme old age. Therefore, all authorities have provided these documents, citing the case of Chigongo Farouk versus Uganda, ruling application number 7 of 2024, cited with approval in Makoha case, where the Honorable Court stated that I firmly believe that this court is in making its decision must be cognizant of the socio-economic environment in which justice is dispensed, particularly the informal nature of the employment of the majority of Ugandans, that makes it difficult to possess documentary evidence of capacity to meet monetary obligations. To insist on documentary proof of capacity to meet monetary obligations in the event that the suit is called upon to fulfill the bond is to exclude swathes of the population of Uganda from the opportunity to stand surety for relatives and friends. This would tantamount to discrimination against a section of the society on the basis of their socio-economic class. The courts have long held the view that if courts are to simply act on allegations, fears, or suspicions, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. Counsel for the applicant submitted that the respondent provided no evidence to rebut the grounds relied on by the applicant in support of their applications. It was prayed for the applicants that this honorable court finds that the applicants have each satisfied the requirements in the law and on the applicable facts to enable this honorable court to exercise its discretion in their favor and release them from custody on bail on reasonable terms. Determination. 1. Analysis of the law and the evidence. Article 23, 6A of the Constitution provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Although the Constitution guarantees an accused person the right to apply for bail, the court at all times retains the discretion whether or not to grant an accused person bail. See Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006. The primary principle for which a court may release an accused person on bail pending trial is the presumption of innocence. This legal principle is enshrined in Article 28, Subart 3 of the Constitution, which provides that every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Section 15(1) of the TIA, in addition to upholding the right of accused person to apply for bail, clothes this court with the discretion to release an accused person on bail at any stage of the proceedings. Guideline 5 of the bail guidelines provides the general principles which a court may take into account while considering a bail application. The principles include the presumption of innocence, the right to liberty, applicant's obligation to attend the court, the discretion of the court to grant bail on such terms as the court considers reasonable, and the need to balance the rights of the applicants and the interests of justice. Having examined the applicable law on bail, I will now turn to the merits of the application. Right to apply for bail and the court's discretion to grant bail. This grant has already been addressed as above, and it is clear that the applicant has a right to apply to court to be released on bail, with the court having the discretion whether or not to grant bail under Article 23(6) of the Constitution. Presumption of innocence. The principle of presumption of innocence is a constitutional one, and as noted above, the bail guidelines require this court to consider the principle of presumption of innocence and personal liberty in determining bail applications. In relation to personal liberty, the active principle in granting bail is that of upholding the liberty of the individual while simultaneously protecting the administration of justice. See Abindi and another versus Uganda, application number 20 of 2016. The unreasonably, bail should not be refused merely as a punishment, as this would conflict with presumption of innocence. Fixed place of abode and substantiality of sureties. Fixed place of abode. A fixed place of abode for an applicant must be within the jurisdiction of this honorable court, as it guarantees the court that the applicant's accused person cannot be found can be found in the event of absconding. To underscore the importance of the provisions of proof of a fixed place of abode, it can be a ground for refusal to grant bail. It is therefore imperative for the court to be persuaded that the accused person has a fixed place of abode, because it is a pointer to the fact as to whether the applicant is likely to abscond once granted bail. Section 16, subsection 4 of the TIA is instructive in this respect, as it provides in considering whether or not the accused is likely to abscond. The court may take into account the following factors: A, whether the accused person has a fixed place of abode within the jurisdiction of the court, or is ordinary resident outside Uganda. The point made in section 16, subsection 4, part A of the TIA is amplified by paragraph 13K of the bail guidelines. While the law does not define the phrase fixed place of abode, what is important is that the fixed place of abode must be within the jurisdiction of the court, considering the bail application. Where the applicant fails to prove this under section 16, subsection 1 of the TIA, then the court may deny him bail. In the case of Foundation for Human Rights Initiative versus Attorney General Constitutional Petition number 20 of 2006, it was held that the nature of the offense, antecedents of the applicants, and whether the applicants have a fixed place of abode in the course of this jurisdiction should be strongly considered by the court in an application for bail. Remy Kasule J. in Mugenyi Stephen versus Uganda, business application number 65 of 2004, held that the onus is on the applicant to satisfy the court that he has a permanent place of abode in a particular village, sub-county, and district. This is to enable the court to exercise its discretion, to exercise its jurisdiction over the applicant, while on bail being able to trace his whereabouts whenever it is necessary. In respect of this application, the applicant stated that that under paragraph 3 of the notice of motion and paragraph 1 of the first applicant's affidavit in support of the application, that he has a fixed place of abode within the jurisdiction of this court at Buyinja LC1 Wampe Ward, Kasanga Town Council, Wakiso District. And Rakabengo A, Rakabengo Ward, Southern Division, Konjiri Municipality in Konjiri District, within the jurisdiction of this court. The applicant submitted a copy of his national identity card, the original of which he submitted for court inspection, and an introduction letter endorsed by the chairperson of Boyenja LC1, Wampeo Ward, indicating that he is a resident in his area of jurisdiction. The second applicant says that he has a fixed place of abode within the jurisdiction of this honorable court at Sigula Village, Sel Mutundwe Ward, Gombolola Sabagabo, Makinde Wakiso District, within the jurisdiction of this honorable court. The applicant submitted a copy of his national identity card and an introduction letter endorsed by the LC1 chairperson of Sigula Village, Cell B, indicating that he is a resident of his area of jurisdiction. Paragraph 12A of the bail guidelines provides that an application for bail shall contain particulars of the applicant. And then the introduction letter from the chairperson where the applicant is. Introduction letter are well known and are within the jurisdiction of this honorable court. Excuse me. By furnishing court with a copy of the national identity card and an introduction letter from the chairperson of LC1, the applicant has satisfied the onus placed on him to prove he has a permanent place of abode. C. Kayongo Bashir versus Uganda, criminal application number 158 of 2019. Therefore, the applicants have satisfied the requirements to prove a fixed place of abode. B. Substantial sureties. The term surety is defined by paragraph 4 of the Constitution, Bail Guidelines for Courts of Judicature, Practice, Directions, Legal Notes number 8 of 2022 for court inspection. 2. Honorable Muhindo Harold Tony, a 52-year-old male adult, member of Parliament for Bukonzo County East, a resident of Katale Busaula Chengera Town Council. Honorable Muhindo is the first applicant's close friend. On file, an introduction letter from the LC1 chairperson of Katale Busaula Cell, Chikajo Ward, Chengera Town Council, Wakiso District, indicating that Honorable Muhindo is a resident of his area of jurisdiction, and a photocopy of Honorable Muhindo's national identity card. Honorable Muhindo presented his national identity card for court inspection. Photocopies of the documents are on record. Honorable Francis Mujuche, a 41-year-old male adult, member of Parliament for Bukwejo District, a resident of Lutete Kelezia Cell, Masoli Ward, Kasanga Town Council. Honorable Mujuche is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Lutete Masoli Kelezia Cell, Masoli Ward, Kasanga Town Council, Wakiso District, indicating Honorable Mujuche is a resident of his area. And a photocopy of Honorable Mujuche's national identity card is on record. Honorable Mujuche presented the original of his national identity card for court inspection. For Honorable Kamara Nicholas Thaddeus, a 50-year-old male adult, the MP for Kabale Municipality, a resident of Buye, Chigowa LC1 Bukoto 2 Parish, Nakawa Division. Honorable Kamara is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Buye, Chigowa 1 LC1 Bukoto 2 Parish, Nakawa Division, Kampala, indicating that Honorable Kamara is a resident of his area, and a photocopy of Honorable Kamara's national identity card is also on record. Honorable Kamara presented the original of his national identity card for court inspection. The second applicant presented three sureties as follows. Najita Halima Lutale, a 58-year female resident of Kisugu, Makindi Wakiso district. She is the wife of the second applicant. She is a businesswoman engaging in business with her husband. She presented an introduction letter from the LC1, chairperson of Kisugula village cell, Mutunde Ward, Gombolola Sabagabo, Makindi Wakiso district, indicating that she is a resident of his area. Mrs. Lutale presented the original of her national identity card for court inspection. 3. Siwankam Hamza, a 48-year-old male resident of Kanabe village, Ndege Parish, Sabagabo Makindye, Wakiso district. He's an advocate practicing with Soankambo and company advocates. Mr. Soankambo is the brother of the second applicant. He presented an introduction letter from the LC1 chairperson of Kanaba cell, Ndeje Ward, Ndeje Division, marking the Sabagabo municipality, Wakiso district, indicating that he is a resident of his area. Mr. Sewankabo presented the original of his national identity card for court inspection. 3. Naf Kazura, a 27-year-old female, resident of Lukuli Konge Parish, Tiaba Zone, Kampala district. She's a journalist by profession. MS Nafuka is the daughter of the second applicant. She presented an introduction letter from the LC1 chairperson of Tiaba Zone, LC1 Lukuli Konge Parish, Makinde Division, Kampala district, indicating that she is a resident of his area. MS Nafuka presented the original of her national identity card for court inspection. By presenting the originals of their national identity card, the letters of introduction from the chairperson LC1, where they ordinarily reside, the sureties satisfy the conditions set out in Guideline 15 of the bail guidelines. The aforementioned guidelines do not provide guidance on the format the introduction letter should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. I am not persuaded by the respondent's argument that the first applicant's sureties are not suitable as sureties, owing to the fact that they are friends and not blood relatives, younger than the applicants, and therefore are not able to execute their duties as sureties. The first applicant's sureties are his close friends and leaders in a political party of which the first applicant is a member. By virtue of their position as close friends of the first applicant and leaders in a common political party, they are able to exert influence over the applicant to ensure that he abides by his bail terms in the event that he is released on bail. The fact that they are younger than the first applicant, notwithstanding, reference to age in the bail guidelines as a parameter for determining suitability of a surety does not indicate that a surety must be necessarily older than the applicant. It is enough that the surety is a responsible adult with a connection to the applicant, capable of exerting influence on the applicant to comply with his bail terms. In the premises, I find the first applicant's sureties substantial sureties capable of exercising authority over the first applicant to ensure that he abides by the conditions of bail in the event he is granted bail. The second applicant's relationship to his sureties as husband, father, and brother respectively. The fact of their being younger than the applicant notwithstanding, in my view, arguments their ability to compel him to comply with his bail conditions in the event that he is granted bail. It is enough that the sureties provided copies of their national identity cards and introduction letters from local council chairpersons of the areas where the sureties are ordinarily resident, as set out in paragraph 15 of the paragraph 15 to A and B of the bail constitution guidelines for courts of judicature, practice directions 2022. The aforementioned guidelines do not provide guidance on the format of the introduction letter that should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. Accordingly, the declared relationship between the sureties as close friends presented by the first applicant arguments their suitability as sureties. Also, the declared blood relationship between the second applicant and his second and third sureties and the relationship of the first surety as the wife of the first applicant admits their suitability as sureties. Although, as one of the factors to consider in determining the suitability of sureties, the bail guidelines mention age. It does not, in my view, indicate that the surety must always be older than the applicant. It is enough that the sureties are adults in positions of responsibility or so as so connected to the applicant that they are able to exert pressure on the applicant to comply with their bail conditions if granted bail. To say that a surety must always be older than the applicant is to set a dangerous precedent where senior citizens of very advanced age may never be able to find the sureties who are older than them. I therefore find that the first and second applicants have satisfied the requirements to present substantial sureties. Exceptional circumstances. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda vs. retired Colonel Dr. Kizza Besigye Supra. That proof of exceptional circumstances application for bail is not mandatory. In this application for bail, however, the first and second applicants lie on the advanced age as their exceptional circumstances. Section 16, subsection 3, part C of the TIA provides that exceptional circumstances include the infancy or advanced age. There's no doubt that the applicants are 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, subsection 3, Part C of the TIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Uganda Road Court. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Uganda Road. By interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail, and it has not been proved that before he had deliberately or for no justifiable reason failed to abide by bail terms. Gravity of the offense, nature of the offense, and possibility of delay of commencement of trial. Counsel for the applicant cited the case of Makoha Samuel and 35 others versus Uganda, where the applicants were granted bail while being charged with terrorism, contrary to Section 6, subsection 1b and Section 2 and subsection 2, Part B of the Anti-Terrorism Act. It was submitted for the respondent that the applicants in this case of Makoha Samuel and 35 others versus Uganda Supra are charged with terrorism, which attracts life imprisonment on conviction, while the applicants in the present case are charged with treason, which attracts a sentence of death upon conviction. I am persuaded that on the scale of gravity, the charges against the applicants in this case attract the ultimate penalty and therefore are graver than the charges against the applicants in the case of Makoha Samuel and 35 others versus Uganda. While the charges in both cases are grave, the charges in the present case, in the present application, are more serious. As for the applicants, stated that the International Crimes Division of the High Court held in granting the applicants bail in the Makoha case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, basing on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In the Uganda DPP versus Colonel retired Dr. Kizza Besigye, question refers number 20 or 2005, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant submitted that no evidence has been adduced in support of the averment that the offense impacts on the national security of Uganda. It was added that the investigators have placed nothing before this court to suggest that there is evidence of any nature at all of it, suggests that what they aver. In their response to this point, as for the response submitted that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation and witnesses. It was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. As for the applicant cited Panju versus Ara, 1973 African Law Reports at page 282, where it was held that allegations of interference with the witnesses must be substantiated, that such substantiation is not difficult to show. In reply, counsel for the respondent submitted that the first applicant is a prominent and influential person, and the second applicant is his personal assistant. That in releasing them on bail, will accord them the opportunity to interfere with witnesses and investigations which are still ongoing. As for the respondent, on the case of Okello Augustine versus Uganda, application number 6 of 2012, where the court emphasized that once, once the likelihood of abscondment and interference with investigations have been established, the court should be hesitant to grant bail. In this case, the respondent stated that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to state in detail how the applicants are likely to interfere with the investigations with which are ongoing, the particular circumstances of the case against the applicants must be borne in mind. The offenses are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere with the likelihood to interfere with the investigations which are still ongoing. Decision. The main considerations for bail for release on the main consideration for release of an accused person on bail are the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty except in execution of the sentence or order of a court, whether established for Uganda or another country, or of an international court or tribunal in respect of a criminal offense of which that person has been convicted, or of an order of court punishing the person for contempt of court. Article 28, 3A of the Constitution provides every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Article 23, 6A of the Constitution, in recognition of the fact that liberty may be curtailed even where a sentence or order of the court is pending, provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Article 23, 6 of the Constitution entitles accused person to apply to court to be released on bail. It is clear from Article 23, 6A of the Constitution that accused persons, in respect of the gravity of the offense, are entitled to apply to be released on bail. However, the discretion remains with the court to grant or reject the application for bail. See Uganda versus Kano, retired Dr. Kizza Besigye, Constitutional Reference number 20 of 2005. Among the considerations for exercise of this discretion is the gravity of the offense. Courts will more readily grant bail or less for less serious offenses than the serious offenses. The offenses with which the applicants are charged are among the gravest, if not the gravest, offenses of our statute books. In all cases where applicants are charged with capital offenses, the court must always have in its mind the overarching consideration of the gravity of the accusation against the applicants and the sentence that it attracts. As stated in the case of Okello Auguste versus Uganda, Supra, while acknowledging the release of one accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The circumstances of the present case are that it is alleged that the offenses were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offences are, are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in respect of offences alleged to be committed only in Uganda. It was argued for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigation will conclude, to facilitate the committing of the applicants for trial to the High Court. As for the applicants, says that there will be therefore this substantial delay in commencing the trial. Article 23(6)(c) of the Constitution provides that where a person is arrested in respect of a criminal offense, only by the High Court, such a person shall be released on bail on such conditions as the court considers reasonable. If the person has been remanded in custody for 180 days before the case is committed to the High Court, I am of the opinion that this provision takes into account circumstances like the circumstances of this case, where a person, where one reason or another, investigation cannot be concluded speedily, and provides a cap on the time on remand, without committal beyond which time the accused person shall be mandatorily released on bail. To safeguard against the right of the accused person to liberty being indefinitely curtailed. Where the applicants for bail have not yet clocked mandatory bail, bail is a matter of court's discretion, as provided under Article 23(6)(a). In this case, the applicants have, among other factors, proved they have a fixed place of abode, have substantial securities, are of advanced age, and are of first-time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, when granted bail, the applicants did not abide by the bail conditions. While the first applicant has charges pending against him at Uganda Road Court, for which he has cited in John Muhango's Kashaka versus Uganda, Supreme Court Missions Application number 18 of 2023, all factors of to a bail application, all factors to a bail applicant's credit, including being a first offender, being advanced age, having a fixed place of abode, recede to the background when weighed against the seriousness of the offense. In Young versus Uganda, Court of Appeal of Uganda, Missions Application number 99 of 2013, it was stated that the granting of bail by court one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail and reaches a decision based on the rules of reason, justice, and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial securities, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. One, the charges against the applicants are among the gravest, if not the gravest, on our statute books. The offences are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offences alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigations. Signed, Rosette Comfort Kania, Judge, 11th April 2025.
We shall overcome.
We shall overcome. We shall overcome someday. In my heart, I do believe we shall overcome someday. I do believe we will rise.
How are you, bro? Yes, I can continue. Continue. Talking real quick. The court is done and the bail is being denied by the judge of this high court. That is also Aaron Kizza, as you sit there getting some discussion, getting some advices from his fellow workers. Yeah, we are going down. This is the Heather Media. Subscribe, like, and comment. Let us tell me where are you watching us from. It is the Heavy Media. As you are watching us, we are going to proceed with the interviews outside this building. So keep in touch. In a few, we shall be keep in touch. Monday, morning. How is it going? Yes, as you see what's going on there. They are trying to look at the different views of different purposes of Dr. King's investigation. Most of the data was received. It was raised in the first space as if they are going to get a bail, but unfortunately, it was not granted. And as you see what is going on, it is the team, the legal team of Dr. Kizza Besigye. You see what is going on. Nini. Morning. Morning. How's it going? Going on right now? As lawyers, we have done everything correct and right. Mukitegera? Mukoze bintu naye omukazi alaze powerful maba oli ekyo nakyo kyadda kazi olabye obuyayi birayo byennyini bafudde mpempu that decision is not based on some other politics, just not a legal decision. You can't uphold. You cannot uphold all. Never also. You cannot uphold all the laws. Because all the conditions have been fulfilled. You cannot you can't uphold all the grounds for the We are live at the under High Court The situation is so tight as you see. This is the Heavy Media. Subscribe to the Heavy Media, like and comment. You better tell me where are you watching us from. You're an original MC Headlight reporting this one. These are all fans of Dr. Kizza Besigye. We are watching the Heavy Media wherever you are watching us from. I'm watching from this place, and we move on bit by bit. We have a lot of councils who are going to talk to us. Doctor is likely right now to get out. Doctor right now is likely to move out and is going out. The crowd you see here, that is all crowded. It is a lot of numbers here, ladies and gentlemen. Dr. Kizza is being today. He came for a bail application or bail release. They have not granted him, and with Dr. Hajji lutale, they have not been granted a bail today. So these are the fans, these are the supporters, these are the voters of Dr. Kizza Besigye. We don't know, or Dr. Kizza Besigye is coming back in this sort of so-called protesting vote. We don't know. We shall see what is going on. Whoever watching us from here, this is the Heavy Media, ladies and gentlemen. It is yours truly, Simon. Simon Official wandipadde ku ssente kati. Simon Official keke mwandintandise okumpa ku ssente kubanga munfunamu nnyo baganda bange. Ebintu bino ndi mubbibawa ssente mu abasinga ozifuna. Simon Official noonyaako tulabe ng'ekintu tukikwasaganya.
Tamusobola kuleka ababbi ababesezeza bbanga abakkati nemukwata omusajja talina musango ababbi mwoye.
What you are seeing here are preparations. The doctor is coming out right now. As I see, those are the councils. Those are the legal team. Doctor is out now. Doctor is being put in the drone, as you see, going back to the New Zealand maximum prison. The legal team of Council Area Sirikwago, as you see. Come on. As you see, doctor is being taken back to the maximum prison of New Zealand, and they are getting back. This is the convoy. The convoy, and it's gone. So we are going for a press brief here in a few minutes, getting what is going to transpire from the legal team and the legal councils.
With this very ruling which we have given to me, and just to understand from here what happened, the ruling, as many of
Why?
how you receive this ruling and what type of ruling you term this to be.
It's a dark moment for us. It's a dark Friday. It defeats logic. Dr. Besigye, and in the judgment you have heard, she has severally quoted Dr. Besigye's cases where he has previously been charged with the same offenses: treason, terrorism, rape, and what not. And these are all grave offenses. And in all those offenses, he was admitted to bail. So what is so exceptional? about this particular charge. We are even short of words because the cases she has been referring to, where Dr. Besigye was charged with the same grave offences, he was admitted to bail. And she has recognized that actually he never jumped bail. And in all those cases, he never interfered with the sureties or the investigations, rather with the witnesses. He never in any way or at all interfered with the investigations. She has also recognized the fact that he has been on remand for over 120 days. And the investigations have not been concluded, and they have not even made any summary of the case to be presented to the High Court for trial. In other words, actually, there is nothing that is going on as far as investigations are concerned. The time they have had since 16th November last year was sufficient for them to conduct the investigations exhaustively and assemble whatever they wanted to present before court for trial. So it's the reason we feel disturbed, we feel disillusioned, and in as much as we respect the judge and the decision she has made, we take exception to the same. We are grieved by that decision, and we are retreating to our chambers. We are regrouping as lawyers, chart a way forward to explore other available options, because as you have heard, we canvass each and everything. All the arguments one could present were canvassed in this particular case. You heard she adumbrated everything, all the arguments, the plausible arguments that we presented. And now we have to explore other options. Of course, this is the matter of exercise of discretion. An appeal may be out of question. There are precedents to that effect, that a decision in the exercise of the High Court discretionary powers may not be amenable to appeal. So it may not be appealable as of right or in any way. But there are other options under the law which we are trying to explore. From here, we are going to have a meeting and see the options available, including seeking for redress from other jurisdictions away from here, including the East African Court of Justice and others, which I may not mention here. But now, decision is taken. We've got to explore other options away from the jurisdiction of this country. In a nutshell, this is a political decision. It's not a judicious decision. Not a judicious decision. In other words, it's injudicious to deny somebody rights which are guaranteed under the Constitution on such flimsy grounds. It's injudicious. So it's not guided by law. The decision is not guided by the tenets or principles of justice, but obviously influenced by other extraneous matters which are political in nature. That's all I can say in summing it up. It's a decision influenced by extraneous factors which are political in nature, as opposed to matters of law, as opposed to the tenets governing dispensation of justice. That is the summing that I can give. Decision eno ewunyisiza nnyo. Eno ya bulabe nnyo nga bwe mbagambye eri jurisprudence yaffe ku bail. Baluli kibadde nti omusango ne guba munene gutya nga basobola okuwa bail. Ono omulamuzi akikyusizza aga nti singa omusango kati guba munene nga treason oba terrorism oba rape, kooti tejja kuwanga bail. Ekyo kya bulabe. kizibu kati kooti okuwa bail ng'omusango gwa treason oba y'ensonga yokka gy'awadde nti omusango munene ate nga amaze okukiraga nti yakamala ennaku ezisukka 20 ku remand. Dr. Besigye ne Obedi babakwata 16 November last year. Ekyalibadde kimumala n'omumala ogamba nti obudde obwo bubadde bumala state okumaliriza investigation zaayo kubanga bw'oba watandika mu 16th November last year okunoonyereza kati tuli mu April kiikyo kiba kyanoonyereza ekitavvu. So kyalibadde kiwedde akaseera kano in fact ze zaalwadde n'ensonga gaga nti state ebadde n'obudde obumala obunoonyereza n'olw'ensonga eyo tumutadde. So tuli bennyamivu nnyo, tuli banyiikaavu olw'ensalawo y'omulamuzi eno etali ya mu mateeka naye ng'ate ya byabufuzi. Tuli banyiikaavu okuba nti jurisprudence waffe amateeka agakwata ku bail gakyusibwa omulamuzi. Tuli banyiikaavu nti ssemateeka ayisiddwamu olugaayo kuba kakati right to bail efuuse enzibu okusinziira ku decision eno era state egenda gikozesa nnyo mu misango mingi egy'ebyobufuzi. Bagenda gikozesa nnyo kyebajja okukolanga kuggulako treason, terrorism nga baga gw'olirayikira okuinterferinga with evidence oba n'abajulizi oba ne investigations therefore tukumye bail. So eno judgment egenda kutusiba ffenna, egenda kusiba bangi ab'ebyobufuzi ya bulabe nnyo. N'olw'ensonga eyo tulina okugirwanyisa si lwa ku Dr. Besigye yekka ye muvumu nga bwemulabye naye tulina okugirwanyisa nga tetukomye wano wokka e Uganda. Tugenda kuddayo okutuula era oluvannyuma tugenda kufuna meeting tusalewo butya bwe tunoonya ku bwenkanya obutuweebwa mu mateeka ag'ensi yonna kuba tebikoma wano Uganda. Waliwo kooti eya East Africa, waliwo kooti y'olukalu lwa Africa, waliwo ne kooti endala. So tugenda kutuula tulabe bwe tufuna obwenkanya ewalala yadde nga na wano tukyagenda mu maaso n'olutalo lwe lumu naye tulina okufuna justice ebweru wa Uganda mu jurisdictions endala.
Thank you very much.
Kanso mumuwulidde ensonga ze muziwulidde zonna. Kanso oba tukolere wali soko gye tukolera
Uganda. Okusookera ddala tuli bennyamivu nnyo mu makya ga leero ensala ya kkooti eno omulamuzi Kania gy'akoze ffenna etwewuunyisizza nnyo era nga mu mbeera eyo tetufunye bwenkanya omulamuzi olw'okutuma bail. Okusooka njagala okubategeeza nti tulina ttiimu ya bannamateeka esinga okubeera amaanyi mu Uganda nga namwe bwe mugira terrorist babawa bail naye ate Dr. Besigye gw'okyaginze treason. Ennyingo eya 28 mu ssemateeka wa Uganda egamba nti buli munnayuganda akyagingibwa omusango gwonna ogwa buli kika alina eddembe okweyimirirwa bail lwa nsonga nti ennyingo ya 28 egamba omuntu oyo anaabanga talina musango okutuusa nga kkooti emaze okugumusalira. Naye mu nsala ya leero omulamuzi alinga amaze okugusalira Besigye ate ng'omuwaabi wa gavumenti agamba okunoonyereza tekunnaba kukolebwa. Kakati omulamuzi akijjawa nti bano omusango guyinza okuba gujja basinga ate ng'okunoonyereza tekunnabaako we kwabadde. N'olwekyo kiraga bulazi nti omulamuzi ayina influence endala ezimuleetedde okusalawo nga bw'asaze. Akantu kano nabadde nkagyeko nga kapajja kamu.
okube obbakinga mukko Aaron guno wano. Council, is it going to be an exclusive? Okay. Muganda wange oba olina okusembera abantu wakwetegeka omanyiwo. Council, pasika soko gye tukola akantu ne Aaron. Mirira wange.
So today's decision is an absurd reflection of the terrible consequences military dictatorship can visit on the population, on the country, and very adversely on the fundamental human rights and freedoms of individuals. You can see that even the judge couldn't find a legal reason for denying the dual bail, but he had to rely on some speculation ultimately to make this decision. I'm sure even the court is not happy with the decision that has been made, but the military dictatorship in which this decision gets made must not be lost on anyone trying to make sense of it. The solution to the...
You're still on, and if you're still following,
ensonga zonna tuziwangudde nesigambibwako omuntu okweyimirirwa ensonga yokka eri mu ndowooza y'omulamuzi ndowooza enaakyuka mu ndowooza y'omulamuzi omulala kuba yagamba mu ndowooza ye mu ndaba ye okusinziira ku musango guno okuli Dr. Kizza Besigye n'obujulizi obukyayetaagisa asaanidde mu embeera yonna eyo gye tulina okufumbira bakase kooti eno tunaatukomyewo ekyo kiriiwo oba influencing nti ebiseera ebirala omusango gwe gumu mu mbeera ze
Davis, so kompe ku kakaadi ako ndabe.